as we continue with the broadcast. Now, in our top story, the High Court has today declared the Affordable Housing Levy Act constitutional, stating it was properly enacted. A three-judge bench sitting at the Milimani Law Courts on Tuesday dismissed all the 6 petitions that sought to declare the act unconstitutional, citing inadequate public participation during the formulation stage. The judges in their findings said proper public participation was conducted. The case was filed by Busia Senator Okiya Omtatah, activist Eliud Matindi, Katiba Institute, and 3 other petitioners. The judgment now paves the way for the Kenya Kwanza administration to implement the act fully. The law was introduced through the 2023-2024 Finance Act, and now here is Clement Masombo with the details.
It was a major win for the government on Tuesday after the High Court declared that the Housing Levy Act was lawfully enacted and is in line with the Constitution. A 3-judge bench comprising of Justices Olga Sewe, John Chigiti, and Josephine Mongare also found that adequate public participation was conducted and due process was followed when establishing the fund. 6 petitioners led by Busia Senator Okiya Omtatah, activist Eliud Matindi, Katiba Institute, and others had filed petitions challenging the constitutionality of the Housing Levy Act. However, the bench said the petitioners failed to prove their case.
We have jurisdiction on the 3 issues that we raised. We also looked at each of the aspects of unconstitutionality as alleged, and we ruled that none of those provisions is in conflict with the Constitution. We also considered the issue of burden of proof and came to the conclusion that the allegations of infringement, that the levy would have the effect of reducing income to below 1/3, those aspects were not proved. So then what that means is that the petitions as consolidated fail, and we have dismissed them.
The petitioners had cited inadequate public participation by the National Assembly, which the judges said was properly conducted before the law was passed.
In the instant suit, we take judicial notice that the stakeholders had already been engaged extensively on the Affordable Housing Act and Affordable Housing Levy. Public participation was not only limited to the Affordable Housing Act. It has to be looked at holistically. Public participation was conducted in respect of the Public Finance Act, where the Affordable Housing Levy was originally introduced and anchored under Section 84 of the Finance Act. The Senate considered the public input, including incorporations of amendments that were subsequently adopted by the National Assembly, shows that Senate gave proper weight to the contribution made by the public.
The contentious Housing Levy Act was introduced in the 2023-2024 Finance Act, where all salaried Kenyans are being deducted 1.5% of their salaries to facilitate the program. The petitioners had also argued that the levy was discriminatory in nature. However, the judges dismissed their argument, saying that the act was meant to provide a framework for the Affordable Housing Programs project and institutional housing.
It is therefore our finding that whether or not the Commission on Revenue Allocation participated in the process of the Affordable Housing Act are non-consequential.
The 6 petitions had sought to declare the act in its totality illegal and unconstitutional, alleging that it did not comply with the law during the enactment. Clement Masombo, KTN News.